Any attorney with a quick announcement? Please give me a reaction button. Let me know that you all are ready to get your case called. Hector, I see you raising your hand.
Yes, Your Honor. Hector Busa for the record, Judge. I represent a Noe Garza Jr. Judge versus Crystal Gongora. Unfortunately, Judge, I do not have the number on the docket that you have in your court.
It's number 4 F3768-218 in the matter of the marriage of Noe Garza and Crystal Gongora.
Your Honor, I've just been retained on this matter, Judge. We filed a notice of appearance. Furthermore, I believe there was some status for some DNA tests. My client has chosen he will not ask for the DNA test anymore, Judge. And if the court can order some mediation so we can get this matter resolved, Judge.
I see Crystal Gongora. Ms. Gongora, are you, can you hear me? Crystal Gongora, you're on mute, by the way. Can you unmute yourself? I see you there.
Yes, I'm so sorry about that.
Okay, no problem. Ms. Gongora, remind me once more, you do not have an attorney, is that correct?
Correct.
All right. And you haven't hired an attorney and are not seeking to hire an attorney, is that correct?
Yes, at the moment, no.
Okay. Now, Mr. Bustos is asking that this case be reset and that his client is no longer requesting a DNA test and he is asking to go to mediation. Do you have any objection?
No.
All right. Court's going to go ahead and order mediation. Court's going to appoint Mr. Bustos. The court's going to. Do you have a suggestion? I was going to appoint Mr. Yuri Heller to do the mediation on this case.
That's fine, Judge. It's not an issue.
All right. All right, Ms. Gongora, the court's going to appoint Yuri Heller as a mediator. I'm also going to give him some time to be able to schedule with you and with Mr. Bustos a time in which that mediation can take place. I'm going to reset this case for 30 days. If in 30 days I don't hear that you all have settled, then we can go ahead and allow more time. But for now, we'll go ahead and do a 30-day reset.
Thank you, Judge.
Let's do June the 8th, 2022 at 9:30 in the morning. That will be in person. So anything after June will be in person. So please be mindful that hearing, Ms. Gongora, it will be in person unless there's an agreement reached at that mediation. Okay.
Okay, thank you.
Perfect.
Thank you, Judge. Maybe excuse, Your Honor.
Both of y'all are excused. Thank you so much.
Thank you.
Mr. Velasquez, what do you have?
Good morning, Your Honor. I have two cases before you this morning, Judge. The first one is, I'm sorry, I don't have the docket number. It's CL 19-2076H, Portfolio versus Gonzalez.
All right, that's Portfolio Recovery Associates versus Eduardo Gonzalez. It's a status conference hearing. Mr. Kettler requested a continuance. Respondent may be negotiating with the company to settle. Do we have any new information on that case?
Yes, Your Honor. I'm happy to report that the parties have settled and we are asking the court for 60 days to finalize paperwork.
It looks, yeah, we're going to give you August the 3rd, 2022, 9:30. Most likely, if that hearing is needed, it'll be in person at the new courthouse, hopefully.
Okay, Judge, thank you. And the second case that I have is actually set for a bench trial this morning, and I'll just wait my turn for that.
Okay, let me go ahead and go to Ms. Orellana.
Good morning, Your Honor. I have CL-18-2835-H this morning.
CL 18, I'm sorry?
2835. 2835, yes. Mariela Alanis versus Irene Ramirez.
All right, and I have Mr. Alanis also present. I thought I just saw him.
Yes, good morning, Judge. Oscar Alanis for the defendant.
All right, great. So this is a mandatory status conference. Do we have any information that you all are sitting at number 2 for the week, but there's only 2 cases set for that week. So, and this is for trial on the 23rd of May 23rd. Docket call would be the 19th. Any information on that from Ms. Orellana, Mr. Alanis? Are y'all ready?
Judge, plaintiffs are announcing ready subject to, I'm currently undergoing a medical treatment. I'm not sure on whether I'd have doctor's appointments that week or not, but if I don't, I'll be ready to go. If I do, then obviously I'd be asking the court for more time.
All right, Mr. Alanis?
That's fine with the defense, Judge.
Okay, so I'm gonna put both of y'all down as ready. Y'all are sitting number 2. This case is, let me see. Number 2, because although this case is older than the other one got bumped. So that's why they're number 1.
Okay.
Let's figure out from them and where they're at. I don't know if anybody here is on that case. Roberto Caranca versus Transcansa USA. Anyone here on that case?
Carlos Hernandez on behalf of the plaintiff, Roberto Caranca. And I believe Rick Zuniga, I don't know if he's on the monitor, is for Trancasa. Carlos and Hall.
And do you have an announcement on this one, Mr. Hernandez?
Yes, Your Honor, you ordered us to mediation 30 days before trial, and we're trying to get in with Scott McLean, but his calendar is kind of booked, and I think it's going to be about 45 days before we can get in instead of the 30 days. We'd ask for a short continuance so we can get that mediation taking place.
All right, let me go ahead and give me a new DCC. All right, May 10th
May 10th?
at 3 o'clock.
May 10th at 3 o'clock.
Okay, so that takes care of that one. So I go back to Mr. Alanis and Miss Oriana, then both of y'all are number 1 for the week. So I guess, Ms. Oriana, the quicker you let me know about your calendar, the better, as a courtesy, just to kind of see where we're at that week. But at any rate, we'll see each other on the 19th of May for
And
trial on the 23rd.
If I get new information before then, Judge, I will certainly let all parties know, including the court.
All right, thank you so much.
Thank you, Judge.
Your Honor, may I be excused?
You're excused, Mr. Hernandez. Thank you. Along
Thank
with
you.
Mr. Alanis and Ms. Oriana, unless y'all have other cases.
That was it for me today, Your Honor.
All right, thank you so much.
Thank you, Judge.
Thank you.
All right, Mr. Martinez, what do you have?
Good morning, Judge. CL 220392H, set for a final hearing.
CL 20, I'm sorry, can you repeat that cause number one more time?
220392H.
All right, Enrique Cardenas versus Christopher Garza, doing business as JCHG Trucking LLC. George Sines, doing business as JCHG Trucking.
That's correct, Judge. I represent Mr. Enrique Cardenas, and he should be on.
All right, is any representative who, either Christopher Garza or representative for the company of JCHG Trucking present?
Christopher Garza has filed an answer, Judge. I don't know if he's on.
Yes.
All right,
Okay.
Garza, good morning.
Good morning, Your Honor.
And then we need Enrique Cardenas. Judge, you may want to pass us now that I know that we're going to have the defendant on. I thought it was going to be a default, but since the defendant is on, maybe we should wait.
Okay, no problem. Is this a case, Mr. Garza, are you represented by an attorney? Or are you representing yourself here today?
At the moment, yes, I am representing myself, but if need be,
Yes, fact.
All right, and Mr. Martinez, do you feel like putting you in a breakout room with Mr. Garza would be fruitful, or is it just something that I should just recall later on this morning?
Let's recall it, Judge.
Okay, sounds good.
We'll be on standby. Thank you.
Sounds good. Mr. Jimenez.
Your Honor, good morning, Your Honor. I have a CL-22-1090.
Right.
Mariana Garcia versus Joseph Rich. I represent Mr. Rich.
All right, this is Mariano Cardenas Gonzalez versus Joseph Rich. I thought I saw Mr. Guerra present.
Hi, sir. He's on another Zoom right now, so I don't know if you want to recall it.
Okay. All right, sounds good. let him know that the case is called, that Mr. Jimenez is here present, and that we will call it here shortly, okay?
Okay.
Perfect, thank you.
Thank you, Your Honor.
Thank you. Mr. Vasquez, Gilbert, what do you got?
Good morning, Your Honor. I have two cases in your court, Your Honor. I have the first one, Del Barrio versus Mr. Livesay, and I believe I see him on the system here, Your Honor.
All right, this is CL 21-1342H, Alfredo Del Barrio, Nelda Del Barrio versus Keith Livesay and Renee Livesay.
Yes.
I'm present, Your Honor.
All right, Mr. Livesay. Mr. Vasquez, what do we have?
Your Honor, we have settled this case. I received a settlement or judgment or an agreement, I'm sorry, a settlement agreement from Mr. Livesay on Thursday. I have not had a chance to review it because I was out of town. I'd like to see if we can reset this for another week, Your Honor, so I can review it and talk to Mr. Livesay about it.
Sure. Mr. Livesay, any objection?
No, I have no objection. I have no objection, Your Honor.
All right, let me go ahead and give you about a week and a half. Let's do the 11th.
The 11th.
May 11th.
I appreciate that, Your Honor. And then I have one more case, Your Honor. Thank you, Mr. Livesay.
Okay.
Mr. Livesay, do you have something else?
No, Your Honor.
All right, we'll see you on the 11th at 9:30.
Okay, thank you, Your Honor.
You're welcome. Mr. Vasquez, the next case?
Your Honor, I have, in the interest of Alexis Elizabeth Maldonado, Your Honor, with Juan Alvarez on the other side of this case.
I'm on screen, Your Honor.
Yes, Mr. Alvarez is present here in the courtroom.
Yes.
Let me find this one. This is number one, F573911-8, in the interest of Alexis Elizabeth Maldonado, a child.
Yes, Your Honor. Gilbert Vasquez on behalf of the father, Omar Maldonado, Your Honor.
Well, I was on behalf of Lori Nicole. She is the mother of the children.
Your Honor, I believe we've reached an agreement. We are set for a final hearing today, but we've reached an agreement where my client has agreed to pay child support in the amount of $300, requested not to change for 3 years. And I think that's pretty much the whole agreement, right?
Yes, that is correct, Judge. The issue that was before the solemn report was a petition for termination, and that was filed by Mr. Vasquez on behalf of his client. And I believe they're going to be non-suiting that particular petition, and just the agreement to the child support $300. That would be the totality of the cases before this court. That would be dispositive.
Yes. And of course, also that we would not be trying to change the child support for 3 years. And we talked about that in the past. And then there was an issue with the numbers. We finally agreed on 300. So
Right.
That should be the whole agreement, Your Honor. And thank you, Mr. Alvarez, for telling the court about the petition to terminate. I forgot about that, the important part. But yes, that is the agreement, Your Honor.
Okay, so how do you anticipate putting this agreement before the court? By way of Rule 11? Do we need to put it on the record? Do we need to swear in the parties? Do y'all need more time and then come back in a couple of weeks and memorialize it by an order that both of y'all sign off on?
We can do that, Your Honor. We can do it by submission because all parties are in agreement.
That is correct, Your Honor.
Okay, so then let me set this up for a tickler in 2 weeks, and that'll give you guys some time to work on an order and sign off by the parties, and then we will work it that way. If everything works itself out, then there won't be a need for an additional hearing, okay?
That is, yes, Your Honor. There will be a motion for non-suit that will take care of the termination part, and then there will be an order modifying the child support to reflect the $300, and all parties will sign off on that portion.
Right. Yes. I'm gonna give it a date, just guys. I'm gonna give it a date, and it's more for a tickler purposes of May the 20th at 9:30.
Yes, sir.
Hopefully the paperwork is submitted, and then we'll just remove it, okay?
Yes, Your Honor. May the 20th, particular. Got that, Your Honor. I have nothing else, Your Honor. May I be excused?
Mr. Vasquez, you're excused. Mr. Alvarez, do you have anything else?
That concludes my business with the solemn report. May I be excused?
Yes, you may. Thank you.
You have a good day.
Likewise.
Okay.
And I know I have some individuals, some lawyers here present in the courtroom. I'd like to take care of them first so they can move on to other courts. Ms. Martinez, you have number 14. Is that correct? Oh, you're on mute. Sorry.
I have two little things, man.
All right. I can hear you there. What number do you have?
Good morning, Your Honor. I have number 14 on the court docket.
All right, that's CL 200056H, Midland Credit Management versus Joel Luna.
Veronica Sepulveda Martinez standing in for the plaintiff.
Right.
Your Honor, if I can proceed with the default judgment.
Is Joel Luna present? Joel Luna, if you're on mute, please unmute yourself. Joel Luna. Joel Luna. Name of Joel Luna was called out 3 times. There being no response. You may proceed with your default judgment.
This time, the plaintiff asks that the court take judicial notice of all documents in the court's file. Copy of the plaintiff's original petition was filed on January 3rd of 2020. The defendant was served on February 14th of 2020. The return has been on file with the court since February 18th of 2020. To date, the defendant has not filed an answer in the aforementioned case. Attached to Exhibit A, the certificate of last known address, and to Exhibit B, affidavit regarding defendant's military status. This time, the plaintiff asks that the court award judgment in the amount of $21,048.38 and court costs in all court costs in this case.
Court will take judicial notice of all documents the court's filed. The court's going to go ahead and grant default judgment in the principal amount of $21,048.38 plus cost of court and all post-judgment interest, as has been requested in the final order that was submitted to the court. That relief is granted.
Thank you, Your Honor. That's all I have. May I be excused?
You may. Thank you.
Thank you.
Ms. Ramirez, I see you there as well.
Good morning, Judge Tana Ramirez. I'm number 2 on your docket.
That's F 477228 in the interest of Rihanna Negrete, a child. I have a note here, a status conference hearing. Was mediation conducted in this case, Ms. Ramirez?
Judge, unfortunately, it was not. We were trying to get the opposing party to literally agree to the mediator. Like they didn't even want to, they didn't want to do it. Literally, they said that they didn't want to go to mediation. So at this time, I'm gonna have to file a motion to compel mediation because my office, we tried constantly, Judge, to contact them, to get them to, and I gave them a list, like given like options of mediators. We did tell them that the fee is gonna be split between my clients and them. They didn't want to do that. So they were just being very uncooperative when it comes to going to mediation, Judge. Now, I did tell them, my office did tell them that the court had ordered it. Now, so I'm gonna have to file a motion compelling mediation, Judge.
All right. Go ahead and do that. Serve them with it. That way, if they don't comply, we have some teeth behind it. Ms. Ramirez, they're not represented by counsel, correct? This is not the case where Rubio Salinas was on the other side, if I'm remembering correctly, or?
No, Judge, and if you recall, like this case has been, it's heavily contested, and the opposing party, they have been representing to this court that they are going to be getting an attorney, and they failed court after court to do that. Now at this time, like if I'm gonna have to go, and like I said, right now we're having an issue. We've been setting up mediation. So if they're gonna want to take this to like a hearing in front of the court, which is probably most likely what's gonna happen, I mean, I just don't know what to do with this opposing party, Judge.
All right. All right. Opposing party is who? Can you give me the names of them?
Let me get it for you. Let me pull it up real quick.
So George Negrete?
Yes.
Jose Negrete.
Let me see.
Jose Negrete and Flor Candanosa.
Yes.
All right. Is Jose Negrete or Flor Candanosa present? Jose Negrete, Flor Candanosa, if you're on mute, please unmute yourself. Jose Negrete and Flor Candanosa. All right, notice was sent to them. Ms. Ramirez, if you can file that motion to compel and then serve them with that motion to compel so that we can have some teeth behind it. I can give you a reset date right now so that you can put it in the order. And that motion
yes.
to compel. Go ahead and give you 3 weeks.
Okay.
That way you can have enough time to locate them.
Okay.
All right, the 25th of May.
May 20.
at 9:30 in the morning?
Actually, Judge, that day, we're gonna be potentially starting a trial for
You know what?
the,
Yeah, I'm glad that, not that I'm glad that there's a conflict, but let's do this. Let's set it up in June, because in June, we're gonna be completely in person, and that will force them to show up.
what date in June? Because and I hate to be, but
Oh,
I'm due June 20,
how about June 1st?
June 1st. That should work. That should work.
June 1st. And that'll be in person.
Okay.
For you, for all parties, in person, June 1st. It's a Wednesday. It's about, I guess, about 3 weeks before your delivery date.
That'll do. The doctor did say that I have to walk a lot, so.
Okay. All right. Well, we'll see you here June 1st, 9:30. Please give notice to opposing party of the date in your motion to compel.
Okay, we'll do that, Judge.
All right, thank you.
Thank you so much. May I
All
be
right.
excused?
You and your clients are excused.
Thank you.
Now I see Mr. Guerra. Mr. Guerra, are you available for Mr. Jimenez?
Can we be excused, Your Honor?
Yes, you may. Thank you, sir.
Thank you.
Yes, sir.
Okay, let's go back to Mr. Jimenez and Mr. Guerra, CL 22-1090H, Mariano Gonzalez versus Joseph Rich. This is a TRO hearing extended from April the 18th. Mr. Jimenez is now making an appearance on behalf of the defendant, Joseph Rich. Have you all had an opportunity to confirm Mr. Jimenez and Mr. Guerra?
No, Your Honor.
No, he just made an appearance, so we can, I think we can either agree by operation of law, because he's not gonna be able to post it until, so maybe it will give us a chance to see if we can reach up some sort of agreement as to the reinstatement amount or the payoff amount.
Your Honor,
How about I put you all in a breakout room? I know that you all probably need to talk about this. I can put you on a breakout room and then you come back, give me an idea as to what it is, Mr. Jimenez, you want to do. And then what it is you're requesting from the court, okay?
Thank you, Your Honor.
I'm assuming you just wanted to, to expire already, but I'll put you in a breakout room. Y'all confer with that.
Thank you.
All right. All right, the invitation's been sent.
Thank you, Your Honor.
Come back once you're done. All right, let me go to Brian Nichols.
Good morning, Your Honor. How are you?
Good morning, Mr. Nichols.
Your Honor, I'm on case number CL 21-2142. I represent Ram Mutual Insurance Company against Mr. Roman Viramontes. I believe Viramontes, Mr.
All right, the invitation's been sent.
Thank you, Your Honor.
Come back once you're done. All right, Mr. Let me go to Brian Nichols. Viramontes, I'm getting a feedback.
Good morning, Your Honor. How are you?
Good morning, Your
Honor. Your Honor, I'm on case number CL 21-21.
Do you have us live on YouTube?
I represent Ram Mutual Insurance Company against Mr. Roman Viramontes.
Mr. Viramontes, do you have me on YouTube? Because that's probably the reason for the feedback.
I already took it off.
Okay, perfect. All right. Let me see here. Is it set for default today? Respondent failed to report for status hearing on March the 30th. And then you were going to submit an order setting hearing, which you did. That's why I'm guessing he's here. Your announcement, Mr. Nichols.
Yes, sir. And I was calling into this Zoom hearing either to pass or to reset the hearing. I have spoken with Mr. Viramontes on one occasion. I believe we can settle this matter. And I didn't know that he would be on this call. We've had some difficulty communicating with each other. But that being said, I am passing this hearing because I think that I can get a settlement with Mr. Viramontes.
Right. Mr. Viramontes, any objection to giving you and Mr. Nichols some additional time to see if this case can get resolved?
No, Judge.
Okay, perfect. Let me go ahead and give you, what do you think? 3 weeks, Mr. Nichols?
I think 3 weeks would be fine, Your Honor. And in the meantime, I'm going to try to call Mr. Viramontes again. I think it's just a matter of working out the actual terms. The last time I spoke with him, it seemed like we were getting somewhere. So I think 3 weeks would be fine, Your Honor.
All right, let me go ahead and give you May 25th, 2022, 9:30.
May 25th.
This will still be via Zoom. Once we move into the month of June, everything will be in person, okay?
Thank you.
You're welcome. We'll see you then, Mr. Viramontes.
Yes, may I?
Thank you. You may be, yeah, I'll call you, Mr. Viramontes.
Okay, thank you.
All right, thank you, guys.
Bye.
Bye-bye. All right, let's go back to Mr. Jimenez and Mr. Guerra. Now I see y'all back from the breakout room.
Yes, Your Honor. Your Honor, I think we've agreed to reset it for 1 week, Your Honor. So that way we can continue talking, Judge.
All right, a reset for 1 week would put us on May 9th, 2022 at 9:30.
Perfect, Your Honor.
Okay,
We'll be back. Thank you. Good to see you, Your Honor.
likewise.
Bye-bye.
Bye-bye. Mr. Hall, are you there? Jared Hall?
Yes, I'm here.
All right, what case do you have?
I represent Geico. This is Geico versus Cesar Zamora, cause number CL-21-3172-H.
All right, is Cesar Zamora present? This case is set for default. This is actual, Mr. Hall. This is a case where the court, in fact, were you aware that that Mr. Zamora filed an answer, or what purports to be an answer, where he's asking for some additional time? Were you aware of that?
No, we don't have an answer in our file, but we can pass this and I'll get my staff to get a copy and we'll go from there.
Yeah, it seems as if Mr. Zamora may be incarcerated in Bryan, Texas, or at least that's the impression I get from the return. It shows a number which I suspect would be some sort of incarceration number. It says Hamilton unit in Bryan, Texas. So if you could take a look at that, he is requesting some additional time. He states a very unique reason for the additional time, but at any rate, he is asking for some more time. I don't mind giving him that time and giving you some time to look into it, okay?
Sure. I'll get a copy of that answer and we'll see what we can do to move this thing along.
All right, let me give you 3 weeks so that we can take care of this before we move into in-person. Let's do the 25th of May.
Okay.
Once we move into
That'll
the
work.
month of June, everything will be in person, okay?
Okay, thank you.
All right, the 25th of May at 9:30.
All right, thank you.
You're welcome.
May I be excused?
Yes, you may.
Thank you.
Okay. Let's see, Mr. Martinez and Mr. Garza. Let's go ahead and go back to, I'm sorry, Mr. Velasquez, did you have an announcement?
Yes, Your Honor. I just realized this is actually set for a default setting, Your Honor. I mistakenly stated that it was on the merits. I don't see the defendant present. So
Can you remind me of the case number one more time?
yes, Judge. So the case at hand is, I have it right here. It is cause number CL-18-4677, Portfolio versus Valdez.
Okay, yes. So yeah, so it's I have it down as a bench trial. Are you saying it's a default?
Your Honor, I believe so. And I went through the and I stand to be corrected by the court, but I went through the court's records, and on April 29th, plaintiff filed, I believe, a motion for default judgment in this case. And I don't see an answer, Your Honor, on file from Mr. Valdez.
I think the outcome is the same. Let me call out his name, and if he's not here, you can proceed with the submitting the same evidence that you're going to submit in a default, and we can just proceed that way. This is PL 18-4677H, Portfolio Recovery Associates versus Abraham Valdez. Abraham Valdez, if you're on mute, please unmute yourself. Abraham Valdez. Abraham Valdez. The name of Abraham Valdez has been called out 3 times in the courtroom door as well as here online. There being no response. Case, let's just assume that it was set for bench trial. Mr. Velasquez, but I'll allow you to introduce whatever evidence you were going to be introducing, and then we can proceed with the with the bench trial.
Yes, Judge. Thank you, Your Honor. So, Your Honor, as stated, I'm here this morning on behalf of Portfolio Recovery. Portfolio filed suit in this case on or about August 30th of 2018. In plaintiff's petition, there were requests for admissions served on the defendant, Mr. Valdez. I would ask the court at this time to take judicial notice of any and all pleadings previously filed with court. I do have that Mr. Valdez was served with citation on or about August 31st of 2018. Citation, in addition to that, he was also served with a copy of plaintiff's petition and plaintiff's request for discovery, which included those deemed admissions. Despite being duly served, Your Honor, defendant has failed to file an answer or any other pleading constituting an answer. And I would again ask the court to take judicial notice of the court's record. I would move the court at this time to admit any and all documents previously filed with the court, including any and all exhibits, Your Honor, evidencing judgment in favor of plaintiff. Right now, we are seeking damages in the amount of $873.20. This does include credit for payments already made by the defendant totaling $100 as actual damages. In addition to that, we are seeking cost of court and we're not seeking post-judgment interest at this time. So with that, Judge, I would move the court to grant all relief requested in favor of plaintiff.
I am showing here, Mr. Velasquez, a default judgment that shows a judgment in the amount of $973.20. I don't know if that credit has been given. Do you mind submitting or resubmitting an updated or an amended default judgment, please?
Absolutely, Your Honor. I will get that filed with the court. Excuse me, Judge. I will get that filed with the court for the court's review as soon as possible.
All right, court will go ahead and grant judgment in favor of the plaintiff and against the defendant in the principal amount of $873.20 plus cost of court. If you can go ahead and resubmit an amended default judgment to reflect the modification, court will go ahead and sign off on that.
Thank you, Your Honor. That's all the business I have before your honorable court. Permission to be excused.
You're excused. Thank you. All right, let's go back to Mr. Martinez. Mr. Martinez, if you can hear me, I'd like to now call you and Mr. Garza.
Hello, Your Honor.
Yes, Mr. Christopher Garza. Mr. Martinez, can you hear me? You're on mute, Mr. Martinez, by the way.
Yes, Judge.
Okay, perfect. This is CL 220392H, Enrique Cardenas versus Christopher Garza. Is there any representative here representing the trucking company, George Signs? Anyone?
Yeah, I am representing the trucking company at the moment, sir. I'm the representative for JCHD Trucking.
Okay. Mr. Martinez?
Judge, we have a partial agreement on this case.
Okay.
Mr. Garza has agreed to return a Freightliner trailer to the plaintiff, Mr. Enrique Cardenas. It's a 2014 Freightliner trailer, VIN 015-111-438-691-11716. He's agreed to return it to the plaintiff by May 16th, Judge. And I'd like to ask the court to pass this hearing until May 20th, when I've got another hearing with the court on that date, Judge, on another civil case. And we'll try to settle it by May 20th.
Mr. Garza, any objection to that?
Yes, I would agree to it, but I don't want, if he's still gonna, continue with the lawsuit, I'd like more time, either to file the countersuit. I would like to resolve this matter if he wants to return it.
So here, let me just kind of read between the lines before we let this kind of get a little bit out of hand. Right?
Yes, sir.
From what I'm gathering, if that Freightliner is returned to Mr. Cardenas by the 16th of May, Mr. Martinez would probably get on and say that there's been an agreement reached. Is that more or less, you just want the 20th, Mr. Martinez, just to make sure that it gets, that the agreement is memorialized by no later than the 16th of May?
Judge, we need the trailer, but the parties are saying you owe me money, you owe me money. So we don't know if there's any money actually owed or not. So we need to figure that out. But Mr. Garza has my client's trailer and he's had it for over 3 months without turning it over to the plaintiff. So I asked for it to be turned over by Friday. He said he needed more time, that he could do it by the 16th. So I thought we had an agreement to return it by the 16th, and then we'll work out the rest. If not, Judge, I'm asking the court to have it returned by this Friday to the client because it belongs to my client. It does not belong to Christopher Garza or the other defendant or the other company.
All right.
And I have my client ready to testify, Judge.
All right. Mr. Garza?
Yes, sir. I told him that if we can return it by the 6th, I would return it by the 16th, but if he's going to cease, or try to, continue, suing us, that, I would return it, by June 1st. I could give him my.
Why the difference? What's the difference? I mean, if it's not yours, why are we using the Freightliner as a pawn?
No, it's not a pawn, sir. It would significantly impact our operations. And that's why we're even in this disagreement in the first place, Your Honor, is that we had an agreement in place, but they changed the terms. And we haven't been able to resolve that. We haven't, as far as mediated with it or anything like that. His client was telling me that there was another partner involved. And due to that, he was not able to make decisions on it because it was his other partner that was involved. And I've discussed it with Mr. Cardenas, his client. But there was, some money that was owed to us as well too. And I told him, well, look, we can work this out. As far as the money that's owed to us, we'll just use the trailer right now and resolve that debt, and then we'll return it to you. But now he contracted Mr. Martinez, or I guess his partner did. And we're in the position that we're at right now. I told Mr. Martinez, when he called me that I mean, if he wants to return it by the 16th, and then, I guess we just both go our own ways after that. I can, we can agree to that, but I did need a little bit more time just because we do have it in operation right now. We've paid money for the trailer as well for the maintenance, several $1,000s as well, just to maintenance that is required for it. And
Judge, I'm ready to go to a final hearing then right now, Judge.
Okay, what are we set for? We're set for plaintiff's motion for final hearing?
Yes, Judge.
Well, can I add something, Judge?
Wait, no, you can't. No,
Oh.
let's see what the judge says.
Are you Enrique Cardenas?
Yes, sir.
Okay. All right.
And I just, there was a correction to Mr. Martinez. It's actually 6+ months that they have not paid rent to me, sir.
They haven't paid rent, Judge. They're using the trailer without authority. They're continuing to use it outright without authority. It's theft, Judge. They've actually stolen the trailer because there's no written contracts.
We have not stolen the trailer, sir.
And
we had the agreement, and we have.
And we want attorney's fees, Judge.
All right, Mr. Garza. So at the beginning of all this, it seemed pretty straightforward. You were gonna surrender the trailer by the 16th of May, which is 2 weeks from today. And then any other issues regarding the contracts that you all were going to have may or may not be resolved by that day, but you were going to continue to be in communication with Mr. Martinez. Then you mentioned that you wanted additional time because you wanted to continue to use the trailer, the Freightliner. But Mr. Cardenas is now saying that they haven't been paid any rent for that use of that vehicle for 6 months.
It's an abuse, Judge. He's abusing the situation because he has possession of the only asset that my client owns, which is that Freightliner trailer. And this man, Mr. Garza, hasn't filed a counterclaim. He hasn't filed anything. The other defendant, Jorge Sainz, is just completely blowing this off.
I've been in communication with him this morning. He's not completely blowing this off. We take this matter very seriously, Your Honor.
He doesn't have a lawyer. He hasn't filed an answer.
Yeah, well, it's set for a final hearing today, Mr. Garza.
Yes, sir.
So I'm prepared to go forward with the final hearing at this point, unless I hear, that there's some agreement that can be reached between you and Mr. Martinez.
And I told Mr. Martinez if they want to, seize and pursue us, that we return it. He goes his way, we go our way, because we've put in some money into the trailer as well too, Your Honor. And there was some money that was owed to us as well too, by the client. We paid for the driver. They started doing different loads, that was not, with us, and we paid for that. So we've paid money, and that's why I had told him, look, we'll return it, and I guess we'll absolve your debt to us, and we'll both go our own ways. Initially, we wanted to pay it, but we couldn't even. They kept on changing off the terms of how much they were even going to charge us for it, and we were going to work out either a loan or something to make an outright purchase.
Judge, we would ask for the trailer to be returned by this Friday. We would ask for $10,500 in unpaid rents, and we would ask for $5,000 attorney's fees that Mr. Cardenas had to spend trying to get his property back, and also for court costs and service process.
All right, this is what the court's going to go ahead and do. The court's going to go ahead and order that the trailer be returned by this Friday. I am going to reset this case for next week in case Mr. Garza would like to hire an attorney to litigate the remaining debt, because that's something that I don't think we're prepared to go forward here today. But the trailer will be returned by this Friday, and I'll reset this case for next Wednesday. Next Wednesday is the 11th of May.
Judge, we stipulated that the trailer is to be returned in the same condition that it was handed to them. I have pictures and everything of the day before they even picked it up.
So, Mr. Cardenas, if it's not, then that becomes a damage issue that I'll take up with him later. I mean,
Okay.
we can stipulate that the sky is green, but we all know that the sky is not green, and then obviously we'll get into damage issues later if it's not, right?
Thank you, Judge.
All right, so by this
Thank you.
Friday, the Freightliner will be returned. We'll see each other next Wednesday, the 11th at 9:30. Mr. Garza, that gives you some time to hire an attorney if that's something that you wish to do, to litigate the issue of the dispute between the money, and then have your attorney make contact with Mr. Martinez. Otherwise, we'll proceed with the remaining, whatever's left of this case, which is the issue of monies, and we'll have you prepare for that. I don't want to ambush you with that. But if the trailer doesn't belong to you, then it needs to be returned as soon as possible. And I feel that this Friday is reasonable.
Thank you, Judge.
All right, we'll see you on the 11th.
Thank you. Maybe
Thank you, Judge. I hope you have a good day, sir.
Likewise, 11th, 9:30.
Thank you.
You're welcome. Mr. Guerrero, what do you have?
Judge, I don't know what number it's on the docket, but I represent Maria Garza Alvarado, who's present here with me.
All right, this is number 3, F06-15-228, in the matter of the marriage of Maria Garza Alvarado del Socorro versus Michael Anthony Arriaga.
Yes, Judge, we do have, I did confer with, I didn't get to speak to her directly with Crystal Garza, but I did confer with their office. We've agreed to mediate with Charlie Ochoa. We do have a date set for that to try to resolve the case of mediation.
Okay.
For the 24th of this month. We are under a temporary order that the court dictated, and we would like extended to that date. I know it's more than the 14 days, but we could extend it beyond that. That way would give us a chance to resolve this case. This is a divorce involving my client, Maria Garza Alvarado, and her husband. And the only issue or the most pressing issue is possession, sale, and access to the home. by both Maria and Michael. The court ordered for them to both stay and behave, treat each other with respect, and that's basically what the orders are right now in this case. I don't expect any change until after we mediate this case.
Okay, so do you have a date when you're mediating with Charlie, or maybe I missed that date?
Oh, yes, the date for mediation with Charlie Ochoa is May 24th at 1:30 in the afternoon.
Then let me do this. I'm going to go ahead and set this up for a hearing on June the 1st in person at 9:30.
First in person, hopefully at the new courthouse, I would imagine.
And no, not in June. Well, that's wishful thinking. We hope to move in July, but yeah, June, we're transitioning into all in person beginning in June, and then the transition into the new courthouse in July, and then we'll go from there.
Thank you, Your Honor. May we be excused?
We'll see you June 1st here at 9:30, all parties present in person.
Thank you.
Thank you. Do we have an agreement, or do we have I have number 9 that still has no answer.